Sure.
Don't dress up. We don't dress up before.
Yeah.
All right, I think we're going to get started. We're about 10:30, so we want to keep as close to schedule as possible because we have some events a little bit later on. So just to start, I'd like to thank everyone for coming today, folks from on campus, folks from off campus. My name is Evan Fasher. I'm the university's Vice Chancellor for Innovation and Entrepreneurship. And under that umbrella, we handle commercialization for faculty, staff, students, early stage businesses throughout southwestern Pennsylvania. So there's a lot of activities that we do that are focused specifically in how do you take an idea and move it towards a place where it may be commercialized. An important part of that process is protecting it. So for the university, one of our roles is overseeing the university's IP portfolio. And in that world, we receive on average every year about 100 new issued US patents. So we're reasonably active as it compares to other universities. We're probably in the top 15 or so of universities around the US for the amount of intellectual property patent focused that we put through the system, although we also work on copyright, so software code and trademarks and whatnot. But we're lucky enough today to have a collection of folks from the USPTO here with us. So from an agenda perspective, we're going to start. Stephen is going to give a little bit of an overview of some of the patenting process. After that, we're going to have a fireside chat when we're lucky enough to have 3 examiners here that you'll get to meet and talk to. So we have Albert, Bree, and Stephen as well, and Robin is going to facilitate that. And when we're done with that, there'll be a little bit more discussion on the eastern region or how the patent office is broken up. Then I'll come back and do some conclusions, and we'll be wrapped up for the day. So with that, I'd like to turn over to Stephen and thank you and the team for coming here today.
Well, thank you for having me, Evan. Appreciate it. So hi, I'm Stephen Yanchak from the Eastern Regional Outreach Office of the United States Patent and Trademark Office. And so the function of our office is to do 2 things. One is have one-on-one stakeholder interactions, and we're really thankful to have all of you in person today and then meeting with us after this to kind of hear what your questions are. Can we be a gateway into the USPTO? Oh, there we go. And our second duty is to connect with stakeholders with trainings, such as this. And so this is my first in-person virtual event, or not hybrid event, but yeah, and it's very different than staring like in a camera. I might just gaze right there because that's what I'm used to looking at, not faces. No, everybody looks wonderful here today. So the United States Patent Office, we are located in Alexandria, Virginia. Like I said, we are the Eastern Regional Outreach Office. Our territory is from Maine to Florida, including Puerto Rico. Soon, hopefully, we want to take the US Virgin Islands, so that way we can do in-person events there as well. We have 4 other satellite offices that are across the United States, and those are positioned to help facilitate intellectual property explorations where people exist as a strong resource. So, intellectual property. I'm gonna break this down first into just an overview of 3 different types of property, right? There's something that you have on you, right? Whether it be your phone, a pen, or pencil. If somebody wanted to get that object from you, it's a physical object that you have, there would have to be some type of physical type of negotiation and communication, right? That it's tangible, you can feel it. Property, like a house, has clear, defined boundaries. But then if we start looking at, like in America, where we have a mortgage and you have property lines, that's actually kind of a new evolution of property, that your lines, the land around you, is owned by you. And that's defended by local authorities and contract laws and the United States government to protect that land as yours. And when we think about intellectual property, this is like the 3rd evolution. It's something that you see in your mind, and then you have to be able to communicate it, whether it's through words, sculpting something, drawing it, to somebody else. And as soon as you tell that to somebody else, they now have all of the information that you had, and then they can just go and act as you. So how do you protect that property? Historically speaking, if we look way back in time, we have cultures that have risen and fallen, and the intellectual property that was developed with the members of their society didn't get passed on to other cultures. It wasn't written down, and why would they write it down? As soon as you share that information, there's no protection for it, so you keep it close to your chest. You don't communicate it. If we look a little bit further in time, we have where people were able to get protections for their intellectual property, but it was more held by the governments. They protected the intellectual property, and they were ones who benefited from it. It's not until we get to the US, where it's written in our Constitution that this right for your intellectual property to be protected as your own comes into existence for humanity. And so the idea of why we do this is what we're going to be discussing here briefly. So by a show of hands, has everybody heard of a patent and a trademark before, right? Can we just get like one or two, like what age did you really start to hear about patents and start to develop that interest or understanding? Or is that today? And college?
In my 60s.
In your 60s?
Maybe a couple of years ago.
A couple years ago, exactly. The first time most people have heard about a patent is in 8th grade civics. And then there isn't additional engagement until college or your 60s. And so the US Patent and Trademark Office is trying to, such as engagements like this, go into the communities and share the importance of intellectual property, because naivety is not an excuse in the court of law. You are held to understand somebody else's intellectual property protections that they have. So, when we're talking about starting a company, we have to start thinking about like, what exactly am I protecting, right? And what types of intellectual property are best suited for my business? We like to have a metaphor it's like packing a suitcase. You have multiple aspects of intellectual property that make up your specific business. And there's multiple protections and different ways in which we can protect those ideas. So the different types of intellectual property, we have our first is our patent suite, if you will. So there's utility patents, design patents, and plant patents. I'm actually going to start from the right and work left. So if you've ever had those grapes that taste like cotton candy or the Honeycrisp apple, those are protected by plant patents. And there's people out there that are trying to innovate in order to help plants be tastier, able to adjust to climate better, be mold and insect resistant, and they can have protections so that way they can financially prosper from their inventions. We have design patents, and this is the ornamentations, where there's not really a function and utility difference between the two different types of designs, but there's an aesthetic purpose, and you can protect that. So the R2-D2 robot is a figure here that kind of symbolizes that. And we do have to thank Shark Tank for popularizing the utility patent. So when they say, is there a patent for that? We're talking about the utility patent because that's the function, right? There is some type of contribution, some type of scientific contribution to the field of endeavor, and then you can protect that in a utility patent. And we're going to get into what that protections grant you as the inventor. But the other forms of intellectual property that we have, trade secrets, which is protected by contract law, trademarks, which is also through the USPTO. We have trademark attorneys that look at all trademarks. And this is a myriad of suites. Colors, names, stylized names, font types with your name, and anything that really symbolizes your brand. When somebody feels a connection with your company, that can likely be trademarked, is a great way to think about it. And so it's brand identifiers. And then lastly, we have copyright. And that's when you fix an art in a tangible medium, right? So sculpting, music, but also for each one of you, you will have a website. And you wouldn't want somebody to directly duplicate your website and change it from .com to a .net, and then try to funnel people into your website, or away from your website into theirs. That's protected under copyrights. Trademarks is probably one of the starting pillars for startups and for SMEs, because it grants you a lot of protection, and it puts out there for the world, or for the United States, in order to say, like, this is my country or my company, and I want protection across the country. Otherwise, you only get protections, like common law trademarks, are only for where you're doing business. And so registering it with the USPTO has a lot of benefits. We're just going to kind of recap that in a more visually pleasing way, where we take the iPhone as an example. So we have their trademarks, which is the Macintosh, Apple, and then the iPhone written with lowercase I, capital P. We do have a utility patent, and what we're looking at here is a casing. But to get all of the different layers and pieces and parts together in an optimized manner, so that way it's durable. When you drop it, it doesn't just fall apart on the inside. Sure, of course. All right. Do you want me to wait or should I keep going? All right. Good. We also have design patents. So these are the things, again, that help symbolize the product that we're looking at, right? The beveled edges, the way the camera looks, feels, and it helps define this product over another product that is also a cell phone. And those can be protected so that way other companies can't infringe on you. And then last, we have copyrights as well, so specific tones that are specific to Apple that allow you to feel connected to that brand through the phone, that can be protected. And then trade secrets, well, we don't know what those are. Diving a little bit deeper into patents, this is really, I think, my purpose today is to provide that overview. Why the patent? Why should you seek patent protection? And it's to exclude others from making, using, selling, offering from sale, or importing whatever your claimed invention is. It is important to say that this is only for the United States, right? It is not, there is no world patent. You have to patent where you want to sell, where you want to manufacture, and then like if you're shipping stuff through, maybe you want to patent there as well. So there is no world patent, and it's protected for a limited term, depending on what type of patent you're going for. The people's benefit. Why this? Why is this system better than what we had before? Well, we want to spark innovation, right? If you reveal not only what your invention is, but it has to be an enabling invention description, right? You have to tell somebody of ordinary skill in the art how to make and reproduce your invention. It's not enough to just say, I have this thing, give me protection. It's a quid pro quo. You tell the scientific community what you invented, how you got there, and in exchange, you get a monopoly on that specific invention for 20 years. What this does is it allows people to learn from your invention and your disclosure and take that next iterative step. About 1%, maybe it's 0.1%, but a very small fraction of all patents that are filed and issued are what we call industry creating patents, right? Where it's brand new, never seen before. Most of them are iterative patents, right? Where it's an advancement, and that's by and large what you get protection for. I think I'm probably going to say this phrase a little bit more over the next couple slides, the aha moment, right? When you are looking at what already exists in your field of endeavor, and then that light bulb goes off, and you're like, I think that this might be new. That's what you want to communicate. Not just what that light bulb is, but how to point B. And maybe you have another one on top of that, and you go to point C, and you want to put all of these descriptions into your patent filing, so that way you can get protection. So who is eligible to apply? Well, anywhere from anywhere. Where can apply for a US patent. As we said, it only protects the creation and sale inside of the United States. But people from outside of the United States can do that and sell to Americans. Who cannot? USPTO employees. We cannot create patents. And it's just the way that it's been. So in the previous slide, we learned that the quid pro quo. You reveal what your invention is, you get a 20-year monopoly. As a patent examiner, I'm reminded of a story that in my very first interview at the USPTO, I was 21 years old, and I'm sitting there across from my supervisor that would take me on if he likes what I have to say. He asks me, what is the point of the patent examiner, right? And I went through what the previous slide said. Well, I want to protect the inventor, make sure that he has a patent that he can take to the bank and not to the courthouse, right? Have the strength of that patent, have credibility and weight. And I want to do a good job so that way the inventor can prosper, and then from that, financial benefit, he can maybe make more innovations. And then this can just, and he's just like, yeah, that's not what I was looking for, right? You are a government employee, and in a capacity, you have to protect the American people. And I will never forget this, and I always like to stress this. On average, there are 3.5 jobs that are created for every patent issued. Now, that's not a linear progression. There's some patents that create a lot of jobs. But as an examiner, we don't know what patent is going to be a game changer. So we have to treat each patent with the same level of, gravitas, if you will. Because if we issue a patent that isn't as strong as it should be, then it cascades down to where that company might have to litigate. And if that company has to litigate, they might have to lay off employees. And so that's who we protect. And that story kind of sticks with me just to kind of present that the inventor and the patent office are trying to work for the same things, to not be the rejection office, but to give you the best claim scope for your invention as it sits against what's already been invented. And I hope that provides a little bit of a framework for why we exist. Again, our types of patents that we have at the US Patent Office that we look at are utility, design, and plant. One of the questions I get when I'm out and somebody's like, oh, you're a patent examiner, that seems really difficult because there's so many things that you can patent. When we come on, they look at what our education is and they put us in a very specific field of endeavor. I've been at the patent office for 14 years. I look at fuel cells and I look at battery patents. I don't look at toothbrushes. I've never seen a toothbrush. I will never see a toothbrush. And it's for the best. I'm not skilled in searching in that field. I'm not skilled in that specific type of technology. But I'm very skilled in fuel cells and batteries. And so each one of these 3 different types of patents has very specific patent examiners that look at them. So you're getting an absolute expert when you submit your patent to the patent office. Yes?
Initially, you mentioned 6 different types.
Yes.
Now you're talking about 3. I understand that trade secrets is a whole different issue.
Contract.
What about trademarks and copyrights?
Great question. Yes, so our 3 different types of patents are the US Patent and Trademark Office, but under that we have, instead of patent examiners, we have trademark attorneys. So they all have a law degree and they look at your trademark that you submit. Copyrights is under the Library of Congress. I believe the current fees for the Library of Congress to have your copyright made official to register it is $10. So, but common copyright is so strong that it's, but yeah. Great question. So in the utility patent, we have processes. So those are like method steps. We have machines, like the actual tangible good that you can protect. A method of manufacturing. So how do you manufacture it versus how do you use it? And then lastly, we have a composition of matter. I'm not sure what, they put a plant there. Really, when they're talking about like composition of matter, it's more like inorganic, organic materials, right? So if we think about a car, right? We can have a million patents that go into that car. If you think about a tire, you can patent the tread, right? You can patent the material of the rubber, right? Maybe there's a specific type of, I don't want to go into the weeds too much, but you can have different types of evolutions that increase durability, that increase the ability for the tire to operate in different conditions. But I just put up there, I'm not going to read each of those. If you pull up the patent, you will see that they typically have these listed sections. When you've been reviewing patents long enough, each patent becomes like a storybook. And so when you're submitting a patent to the patent office, being aware that each one of these helps get the examiner into the frame of what your invention is a beneficial way to submit your application. The title of the invention, as I said, I'm in the battery art. If somebody just says battery, I already know it's a battery. It got docketed to me, right? A little bit better of a description would be like an electrode material comprising X material, right? Well, now I have a clue of what I'm getting into. The abstract is typically written for that age group of probably like STEM-related high school students could probably understand it all the way through college, young adults, SMEs. That's like the audience that you're aiming for. One of ordinary skill in the art at that point in time. And it really should identify what that aha moment is at a very high level. We then go into the figure section, and again, as we're talking about earlier, that difficulty that it can sometimes have from taking your mind's eye, putting it on paper, figures help a lot. You want to be clear about what you're identifying, and it kind of helps sometimes create what scale we're looking at, right? Are we looking at something that's super small, really big? You can kind of help to guide your prosecution by having very clear figures. Now, every now and then, I am an expert in fuel cells, and I am an expert in batteries. Sometimes it's new to me. So the background section, especially if you're on the cutting edge of technology, really utilize this time to set the stage. Where were you when you made that aha moment, right? What was your understanding? And if you put that in the background section, it helps the rest of your application make a little bit more sense to anybody who picks it up and reads it. Your summary section is going to be a very high level. What is the contribution to the scientific space? What is your inventive concept? And why are people going to think this is the greatest thing since sliced bread? The detailed description, as we were saying earlier, it's not enough to just say what the end product is, right? But you have to say how you got there. You have to have an enabling description. And you're going to go through that in your detailed description. Examples are a great way to do this. You start with your raw materials, and then what are the key method steps that somebody needs to take in order to arrive at your end product or your end invention. Without those independent middle states, then you're left with an enabling description of, I have the starting materials. Well, if I find starting materials, how can I just not assume that they would also have your end product? You have to help walk the disclosure such that somebody could reproduce it. And you do that through the detailed description. And then the last part is claims. And as we say at the patent office, the name of the game is claims. That's what's going to define that property lines, right? Just how when you have your house, your mortgage, that clear property lines are defined, that's coming from our claims. And that's what you're going to receive an office action from the USPTO based on what claims you submitted in light of your specification. And so,
Could you read?
Sure.
I don't understand.
Claims?
I'm not understanding what you mean by that.
So at the very end, you make a claim. So, a battery has 2 electrodes with an electrolyte separator, right? The very first battery ever created could claim that. If there's never been anything else, it would have been compared to a capacitor. Well, a capacitor doesn't have an electrolyte in the middle. Sorry that my references are about batteries. Yes?
Is the claims the aha?
The claims are a portion of your patent filing that you write that define what the metes and bounds, what the scope of your invention is that you're seeking protection for. So there's normally like a preamble that would say a battery electrode, and then comprising, and then after that, well, what does it comprise, right? If you're very narrow to one specific type, and again, sorry that all my references off the cusp of my head are going to be battery related. I hope that we can follow. It's like you can put identifying markers. What are the attributes of this layer that is important?
I want to add something. Think about claims as like when you buy a piece of real estate, there's a property line. And it defines where the boundary is, what is yours and what is your neighbor's. And so the claims are going to define what is protected, that's considered your property, and what's outside the claims is what's free for the public to use. And that's why it's important to be very clear in your claims, because otherwise, where do you put the fence, right? And that's really how you should think about claims as to what is protected versus what is not protected.
So could you explain then, I appreciate that a lot, the difference, go back and explain the difference between the detailed description and the claims?
Yes, thank you.
Okay, right. So the detailed description has all of the information. How is everything interworking together, right? How did we create it? That level of detail doesn't need to be in your claims. And it shouldn't be, right? That would be too narrow of a scope if you had to say, like, I start with these starting materials and I add 5 grams of material A, 5 grams of material B, and I do this specific product. That would be so narrow that anybody could just add 6 grams, and now it's outside of the scope of the invention. So we have specific examples in the detailed description and all of the enabling material in that detailed description. But when it comes to the claims, it's more of the overarching scientific idea. Does anybody have anything more to add on the team?
I would say the detailed description is all the information for you to practice the invention. it doesn't necessarily define what is actually being protected. The claim defines what is actually being protected. So it might have a lot of background information, a lot of extraneous details that you might need to know to understand the invention. That's essentially what the detailed description is about. Is educating the reader as to how to understand your invention.
Just to help you out a bit, have you actually read a U.S. patent application before, like gone on to, so that'll help big time. You know, if you just go onto Google and just casually look up like what a patent application looks like, you will actually, one second, Stephen, you'll see all that. So you'll actually see a title, that'll be just right on the front page. Then you'll see the abstract. That'll give you a good idea of what an abstract is. And then you go down through, you'll see the drawings, which come next, just like that. Then the background is some prior history. Like, let's just say you invented the bicycle, right? Like there was you modified like a bicycle, and that was your actual invention. Your background would actually be your bicycle. Okay, so you'll talk about, well, this is how bicycles existed in the past, so on and so forth, and it had like this issue. And that you had to pedal and use your own force. So therefore, I'm adding a motor. And we saw this issue that we have to use our own legs to pedal. And then that's the background. Then you go down to the brief summary and you like expand on that. And detailed descriptions is your invention of like, say, the motor. That would be your detailed description. So you then talk about your bike with the motor, all of that stuff in full detail. And then when you get down to the claims, that's when, Stephen, you want to tie that in, like, and how you would tie the claims in with the example I just gave?
Sure, yeah. So, right, if you're going into the motor in the detailed description to fit inside the bike frame, if nobody's ever put a motor on a bicycle before, then you can say a motor dimension for the frame in the bicycle. So you didn't invent the bicycle. Motors did exist, but the dimensionality hasn't been done. Right? And an examiner may say, well, that would have been obvious. People had motors, they had bicycles, you want to move from point A to point B. Right? That's an obvious thing. But then if you're like, well, but our motor, we had to consider this limited space, and we did this advancement, right? To help, so that way when you're using the bicycle and you're tipping from side to side, it doesn't fall off, right? It doesn't break. There's specific limitations to the bicycle specific that somebody in the automotive world wouldn't have thought of, right? Or in different capacities. So that's a way that hypothetically we could work on this. And it is a case-by-case basis. And I think this is a good time to say that so few patents are filed by the inventors. A lot of people do use outside counsel for this, whether it be an IP attorney or a patent agent, to help draft not only the patent itself, but the claims, right? Because we examiners have been doing this for our whole career, it sometimes can feel like a foreign language in terms of how you draft those claims and the identification of the boundaries. It is a very legal type of exploration. So, yeah.
So on that example, Stephen, so at Pitt, we don't file any of our own patents. We have about 24 law firms that file every single one of our patents. We'll work with them and we'll understand what they're filing, but all of that art is actually captured by a professional attorney, and every single Pitt application is filed and created by a patent attorney.
And that also helps you as the inventor, right? You don't need to pick up a new skill set of understanding law, drafting patent applications. You're the inventor. You're the talent. Keep doing what you do and let them do what they do, and that can help expedite the conversation. This I think is a great example of why the fundamental reason of the patent office is Edison comes out and he says, "I have a light bulb. I want protection for it." People can learn what he did, how he did it, and then they start advancing on top of it. The halogen light bulb, all the way to an LED. LED has lumen capabilities. It lasts longer as long as you have a power source. Right? We don't know if those ancient civilizations ever got to LED lights. Maybe we're the first to see this invention, right? But we have it recorded, and it came about because we had this innovation steps throughout progress. So when you submit an application, the examiner is going to look at whether that invention is novel and non-obvious, right? Novel is it's never been done before, and then the second pillar is non-obvious, and that's, can we just take, disclosure A, disclosure B, and arrive at your invention? And we use the term at the Patent Office, one of ordinary skill in the art. And that can change between different fields of endeavor. If you're inventing a new stroller, well, a mom could be considered one of ordinary skill in the art because they have a lot of experience potentially pushing around different types of strollers. They've seen different types of strollers. So that's your one of ordinary skill in the art. On the other side, if you're in the computer programming world, it's pretty common for undergrads in computer science engineering to work in groups. So the level of one of ordinary skill in the art could feasibly be 4 to 6 undergrad students, and would they naturally arrive at your invention based on these 2 prior art disclosures? So it's a little bit more, it could potentially be a little bit more of a burden. Yeah. And so I did use the word prior art. I didn't even blink because it's just so much part of our vernacular at the Patent Office, but it is anything that is published or printed prior to your filing at the USPTO. So it can be white papers. I mean, YouTube videos can be used in some cases, and so on and so forth. When you should file your patent. We recently, in the past couple of years, transitioned to first to file. So getting that disclosure in front of the USPTO calls dibs, if you will. Like, I invented it today. Of course, you've been working on it, but so as soon as you get that idea, though, get it to us as soon as possible. I have been part of a case where 2 applications were filed and one was a week before the other. The one that filed a week before has the priority, and the one that was filed afterwards, the earlier one was used against it. We see this a lot in history where people on different sides of the globe come up with the exact same invention at the exact same time. And so really, it's a way to help say who invented it first. We just went to first to file. That isn't to say that if you do disclose it, so if you are looking for a US patent, and say you did a dissertation, a PhD defense, and that was open to the public, you want to file your patent based on that dissertation within 1 year, because that could be considered a public disclosure. And so if that's the case, then you want to file, so that way your own work isn't used against you. And then this middle one here about if you want international protection, don't go to a China, like a foreign roadshow showing your product without having at least your provisional patent already in place. And so this is a nice little map, right? You have your invention, your aha moment, you work to get it on paper, and then you can optionally file a provisional application. People file provisionals because then you have that date stamp of when you can get that invention. And so now if you want to get investors, or you want to get legal counsel, or you just want to see the feasibility of the marketplace, you can have a little bit more open conversation because you can always go back to that. Nobody can kind of steal that idea from you because you have that date stamp. But then you will file your non-provisional application. If you did file a provisional, you have 1 year to file your non-provisional. Once you file that non-provisional, you will get an office action from a trained patent examiner at the USPTO. And then eventually you can receive a patent if your invention, based on the claims, is novel and non-obvious. And so what happens if somebody uses your patent? You can ask them to stop. That's the first step. You can create a licensing agreement. And then lastly, you can sue. You can take legal recourse. This is important because oftentimes inventors will use the financial benefit from the first patent to keep innovating, to create the second patent. And so it's not just about allowing people in the field of endeavor to know what everybody else is doing so that way they can leapfrog, but it's also to help financially open up that opportunity for inventors so that way they can continue their work and their research. And so in the slide deck, we have just a couple of educational resources that you can click on at your own leisure. So thank you for this time, and we're going to move over to our second presentation, which is a little bit more, oh yeah, questions. Yeah, let's do some questions.
Are we gonna get a copy of it?
We can, yeah, we can send that out.
Yeah, we have copies. We'll be able to send everyone who attended.
Thank you. Great, thank you.
Yeah. Yeah, coming up and clicking on the screen here might help you much. All right, let me switch this around. Are there any other questions? Was that too fast? I hope that it was helpful.
That's good.
Very good. All right, hand this off to you. If I can invite my colleagues, I'm going to take a seat. So she's going to kind of present a little bit, and then when there's a question that she feels that we can weigh in on, we'll chime in. Are we still in frame
Albert?
to sit? Okay. Oh. All right.
Okay, this is going to be interesting,
Haha.
because I would like to also be able to see the screen as well. So my name is Robin Hilton. I'm a former patent examiner. I examined in the container closure area, so anything that closed the container, I looked at it. Also looked at flexible bags. Did that for almost 20 years, and then I moved over to the International Patent Legal Administration, so I help people with their international patent applications that they file at the Patent and Trademark Office. Today I'm going to go over a little bit of what we discovered when we talked to patent examiners about what it is that makes a good patent application when it's filed. And then my colleagues here will then, I'll ask them some questions and get their feedback on if they agree with those or to expound upon some of our findings, okay? Make sure I click the right one. So again, Robin Hilton. You've already met Stephen Yanchak, Albert Wong, and Pritham Prabhakar, right? So again, we talked to patent examiners, what it is that you want to see in a good patent application to make your job easier. Not only to make your job easier, but to make sure that you issue a good patent, a solid patent, and to make sure that the applicant gets the best quality examination as quickly as possible. Patents are issued in compliance with all requirements of Title 35 of U.S. Code. It can withstand a patent grant challenge. Some patents, I'm sure you've heard about patents being challenged in court. So we're not doing anything bad. We're trying to make sure that our examiners are well trained, that they're professional, that your applications are reviewed in the best possible light to make sure you have a good quality patent. Again, we're really focusing on that quality issue. Again, 818 examiners surveyed. They wanted to identify the attributes that the examiners felt would be the best attributes for efficient and effectively navigating through examination. So there's a scale of 0 to 10, what was not necessary or to what was always essential, the frequency, almost never, and almost always. Okay, so this is what we're going to look at. These are some of the findings. This is a summary. The specification, we talked about the specification. Remember, we did the detailed summary, the background, all of that is the specification, even the abstract, all of that is considered the specification of the application. And you can see here what was, where we fall in it. And we're going to go more specifically into the claims because that's where your patent really falls, is right there. We talked about the claims and we talked about the IDS. Then the IDS is the information disclosure. And what that is the prior art that you, the applicant, would file along with your application. So that means if you find some prior art, if you've done a search or if your attorney has done a search for you, you want to file the most relevant prior art for your application. Sometimes examiners, now again, I said I worked in the container closure area, right? So sometimes I would get a box of prior art. Sometimes I would get 2 boxes of prior art. That was a lot of art to look through, and then I still had to do my search on top of that. Some of that art was not relevant, but the attorney felt that he needed to cite it. So we just want the most relevant prior art, okay? You do have a duty to disclose the prior art. So let's talk about the claims specifically. This is really where your patent application will fall, rise and fall on your claims. So examiners say, you know what? We really want to have clear and correct syntax and grammar. We want to make sure that the terms you use in the claims, we can find those terms in the specification. They needed that 8.76, found it 5.85 times. There's a gap, 2.9%. So what do you think? Do you think that's going to inhibit the first action issue? Are you going to get your patent application granted to a patent quickly? Probably not. So I'm going to start down with Pre. What do you think? What do you think? Is this a relevant for your experience? Do you think this is a relevant gap number? Do you find that to be higher or lower in your own experience?
I mean, I think it's about on par.
Okay.
You know, definitely when you're claiming your invention, you want to make sure that you're clear in your grammar. We call it like the 112 rejections. So the 112 rejections basically like you have to meet a minimum standard by which you write your claim. So essentially it can't be gibberish, right? So like believe it or not, a lot of times you do see gibberish, and then you don't even know what they're claiming that their invention is. So you can't even apply prior art on the claims because they're so nonsensical, you know? So you almost apply a 112 rejection and you're like, hey guys, you got to clean this up before I can even examine the case. And so at that point, it's kind of frustrating, or it can be, because you're getting a rejection in a sense where you have to rewrite all the claims. You don't even see art on the claims because the claims never fully made sense. So you want to try to avoid that situation, you know, I would say at all costs.
Yeah, I don't know anything about patent
Yeah.
review, but I do know the grant review. So do you have a process, like a screening process, and just weed out some...
Like what I described, like a weed...
Yeah, gibberish things, you know.
No, because you don't really know because they're never going to be fully that gone. Like the claims are not going to be that bad, like I'm saying, but they're going to be bad enough that you can't examine them. So, but yeah, they're...
Yeah, the examination is the screening process.
Yes.
So in other words, when you file an application, we'll look at it and we'll flag all the errors and mistakes, and we'll give you kind of an opportunity to kind of correct them, you know, so that if the patent does issue, it's going to be in a very good form with a high quality. So in other words,
when I say screening, basically you just look through, but without a close examination, because it takes lots of time, effort. And you just look at it here, and well, it's obviously doesn't make any sense, so you probably send it back and say, hey,
yes, we send it back.
you can do that, right?
Yeah, we send it back. Yeah, but we also explain what's wrong.
Right.
So we let you know what's wrong, so you can make a decision and say, well, maybe I can modify it and correct it, or this is so bad, there's no way. Let me start all over again. You know.
And keep in mind when you get that office actions that says you've had these errors, you need to correct them. You have to be careful in how you correct them because you can't add what we call new matter, which means what was in the disclosure originally can only be in the disclosure when you rewrite your claims. You can't add anything that was not previously disclosed in your application. Okay?
And previously disclosed meaning, remember we were talking about the detailed description? That is the detailed description. Put as much in there as possible, because later on you can't go back and claim something that wasn't in there. So
when you're talking about gibberish, are you talking like field-specific jargon, or are you talking about it just doesn't make sense? Because I know if you think in terms of like the world of accounting or the world of medicine, there's a lot of very specific jargon. So what?
It's actually both. The examiner may not understand your jargon because your field may be very, very specific. So part of a job of writing a very good application is essentially educating the examiner in terms of your invention, because by definition, an invention is something new. So the examiner, no one else has seen it. It's all in your mind, and you have to take what's here and put it down on paper through figures and drawings and through the written language. And that's where an attorney is quite helpful, because he's very good at that. Not everyone is a very good writer and a good teacher, but some people, have a natural ability to do this. and it's it's very critical. If you have a poorly written specification, odds are your claims will also be very bad. So the foundation is very, very important. And go
I
ahead.
just want to add, that doesn't mean like you don't have to describe every single term. Like you don't have to go through and give a Webster's dictionary of what a catalyst is. These are experts that are looking at it. The idea of one of ordinary skill in the art. If it is an art-specific term, you don't have to define it. You can use that. I think exactly with the idea of grammar and syntax, it's if it's a conflicting statement, right? I've reviewed claims that, okay, we're going down a path A, and then it's like a recitation that now nullifies part of what was just claimed. So do I have to review that or not? And as Pri said, these are all rounds of prosecution. It's time, not only for the examiner, but also for you to respond. And you only get a finite number of times before you have to, restart the cycle. And so what Robin was talking about is setting up your applications so that way you get the best response from the office. As examiners, we only have a certain amount of time to look at your application before we have to move on to the next application. And we are constantly moving on from inventive concept to inventive concept. So the quicker you can communicate to us what your inventive concept is, walk us through your journey, and then provide examples of what your invention is, it tells the story to us. I can follow a story. If it's just fragmented ideas, I spend more time trying to piece together how those fragmented ideas fit together to one common invention. Well, that's time I can't get back. So where does it come from, right? Does the search suffer? Does the response being clearer suffer? Or can I get all of it done in one time? Or where does it come from, right? And so being as clear as possible will get you the best ability to respond in a proactive, and we call that compact prosecution. We want to get the best prior art in front of you for your invention as quickly as possible, and then we can identify the allowable subject.
Stephen mentioned a very good point. The two areas that most people have the most difficulty with in a patent application is defining the inventive concept, which is what actually is inventive versus what's new and already known, and writing the claims. Oftentimes, there's a lot of confusion because the terminology isn't consistent. So, you might change the terminology because you think it's kind of similar, but when we look at claims and things, it has to be very precise. So every word counts, and you don't want to be sloppy in terms of your words. So if you're kind of unsure, look up the definition to make sure that's what you really mean. So I'll give you an example. Something like a button or a key. It's got a lot of components. It has a keycap. It might have some indicia printed on it. It might have some contacts. It might have a spring. When you say the term key, what do you really mean? The whole thing, the button, the spring, the contact? So each one of these things ideally should be defined with their own term and shown in the drawing so we know what's different. And then when you write your claims, you use those same specific terms. And if you start, 1 minute you're talking about a keycap, another moment you're talking about a key, then we could easily become confused.
So I'm not sure if this is something you'll get to or I somehow missed it, but I have a question about prior art.
Mm-hmm.
If I'm interested in a particular kind of therapy. We do a study. The study gets published. That would be an example of prior art.
Right.
But if the study asks for clarification of what we're doing, then am I describing what we're doing, which is what I want to patent? That's the, and therefore, that's kind of.
Yeah, well, repeat the question for you. Yeah. So your question is, what is prior art?
So how do you clarify what is prior art versus? So I feel like if I give a Nobody.
Can I take a stab at it?
Yeah, go ahead. Go ahead.
Yeah, so I think the question is if you put on the very high level, right, what is your concept, right? The concept is a type of idea, but oftentimes concepts alone aren't going to lead to your patentable weight of the scope of your claims. So if you did communicate like, well, we're investigating this type of therapy, right? I mean, agencies, and the National Institute of Science, they put out broad agency announcements. We want somebody to discover this, right? And then those people are like, well, we're researching this. That's not a disclosure. That can't be used against you because that's just a goal. The solution, the aha moment that got you to whatever you were trying to accomplish, that is what would be in the detailed description. And those details then verify what the claim scope is.
But if my reviewers want the aha moment for my publications, I have to put that moment, that explanation in the potential, the manuscript.
Sure.
That loses its, doesn't that mean it?
Unless you filed for a patent.
What?
Unless you had already filed for a patent to protect your idea,
Yeah.
and if you were disclosing your idea to the public without actually filing a patent for your idea is available to the public and is then available for prior art for us to use. Is that what you were?
Yeah.
Yeah, yes.
So then, what's the prior art that I can refer to?
The prior art,
Oh.
the prior art is the body of knowledge of anything that's available to the public. So it could be printed, a paper you publish. It could be an existing item like a water bottle, like that. So it's anything. In other words, the prior art should be different than your invention. Your invention has to be new, and if it already exists in the body of knowledge, which is considered the prior art, then that can't be patented. So in order for you to patent something.
About publishing a paper and so if you need to submit a journal for a journal publication,
Right.
you need to describe your secret sauce because the journal has to decide if this is something worthy of publishing.
Right.
Typically, all these journal submissions we do are under confidentiality. So it's not considered a public disclosure because it's done under this idea of, I have to tell you my secret stuff to get my thing approved. And because of that, we're under confidentiality. And if you're under legal confidentiality, it's not a public disclosure because the public doesn't have access to it. I have access to it only because we've signed a contract that we've agreed that this is not public. So in our world, typically if you're submitting a journal if you're submitting to Cell or Science or Nature, those are typically done under confidentiality, so it's not a public disclosure. So you can submit that, it's not public disclosure. A week later, 2 weeks later, a month later, we submit our patent application, and it's not prior art because it's not art. It's just, it's confidential information between two parties. That would be different if you went and presented in Germany and you talked everything in the public setting, and then we filed an application. That is a public disclosure because there's no bounds of confidentiality in that meeting. But in the journal submission process, that's typically bound by confidentiality. So it wouldn't be considered a public disclosure.
I don't understand what you're saying, but I don't want to take up any time.
So
Any more time?
Okay, so the concept is confidentiality versus public disclosure are two different things. So you can publicly disclose under confidentiality, and it's not public disclosure. And I can give you more of the details after.
My recommendation is if you're really trying to get the hang of what exactly constitutes like a patent application, I would recommend reading through a few different patent applications, even if somebody else is obviously writing it up for you and drafting the claims and so on. Definitely read like 4 or 5 patent applications specific to your technology or an invention and so on. You do that, you'll have some baseline idea, on what we're talking about.
And as was mentioned, you can find published patent applications as well as patents by doing a search, using a search engine. I'm not going to say using Google, but you can use a search engine to do that because Google is a trademark. And we also have a search tool on the USPTO.gov that you can use to search for patent applications that have been published as well as patents. Okay?
You can also go to the Carnegie
PTRC.
PTRC. So it's what does PTRC stand for?
Patent Trademark Resource Centers.
Yeah. And so there's Irene over in the Carnegie Library is a PTRC librarian. And so if you have specific patent questions, she can help navigate the searching aspect.
And to find their information, you can use the search engine of your choice.
Yes.
You know.
Okay, so we're going to move on to the next one. The independent claims that capture the same inventive concept disclosed in the specification. Now here we see a bigger gap, almost 4, 3.8. Oh, I'm sorry. Having independent claims that capture the same inventive concept disclosed in the specification. A bigger gap of almost 4. That could be a problem. So gentlemen, have you seen this lately? I think that's a yes.
Every application.
Yeah.
You know, and it's part of the system, right? Because attorneys want to help give the broadest scope possible for your invention, because then you have more weight when you go out in that field of endeavor. And so it's a back and forth between the examiner and either yourself or your representative to narrow, like to get the claims that you're awarded. What is frustrating though is when the claims are so off from what's invented. It's so broad that it reads on anything in that field of endeavor. And I want to allocate my time to what your inventive concept is, right? But I also want to make sure that I, knock this out of the park, because your claim is just too broad. It reads on everything, even the kitchen sink, right? So one of the things that, just while we're talking about claims, I think the thing that leads me to be persuaded is the nexus of features, right? You have material, or you have like element A, you have material B. Like, what is that combination? What is the significance of it, right? And is that represented in your specification? And so if I can see A plus B and a link of why that's specific, then I can do an adequate search, my arguments make sense to you, and we're going down that proper prosecution.
Do you have anything to add to that?
I think most of the time where this is troublesome is people have heard that you want broad claims for maximizing protection, and people take it way too far. So just a general saying that the scope of protection is proportional to the scope of discovery, or the scope of, or what's disclosed in the specification. So if your specification discloses something like a light bulb, you can't claim all things that generate light, and sometimes, you'll have people write claims that sound just like that, all things that generate light, and all they show is a light bulb. And as an examiner, we don't know what you mean by all the other things. We only know what you disclose. So when you write the claims, they have to be reasonably close to what's in your specification.
And if they're that broad, right, and we as examiners then reject the claim on something that is like, you're like, well, that's not my invention, but that's what you claimed. So if you get a rejection, so it's just in the grand scheme of things, kind of wasting your time and essentially your finances as well, if you're sending in an application with overly broad claims.
Okay, I'm going to give you another example. My water bottle over there has a cap, and this water bottle has a cap. If the independent claim says, I claim a closure, or I claim a cap with a sidewall, a top wall, and threads, that could be either one of those, right? Mm-hmm. But you need to be a little bit more specific, because I'm going to cite an example of that one, and this one, and this one, and any other closure that has a sidewall, top wall, and threads. To be more specific, if you say, I claim a cap with a top wall, side walls, and threads on the inner part of the sidewall, now I can't use this one. Okay. So you do have to be a little bit more specific. It's still a broad claim, because I haven't claimed the mechanism for opening the valve yet, but at least it eliminates this prior art that I'm going to cite for you. Okay?
Great example.
Thank you. I've done that a number of times.
We should carry these props everywhere we come.
Having a reasonable, manageable number of claims. So the office will give you up to 20 total claims, 3 independent claims for a certain fee. If you have more than 3 independent claims, we're going to charge you a fee for each additional independent claim. If you have more than 20, we're going to charge you for each additional claim. Now, there have been times that I know some people get claims and they have 100 claims in one patent application. That is not reasonable or manageable. Gentlemen, have either of you experienced this?
Sure. I've had an application with up to 2,000 claims. You know, with 2,000.
Huh.
Yeah,
Wow.
and most of the time what you do is you kind of send it back and, you know, you say, you know, I mean, more is not better. Better is better. That's really what it gets down to it. And frequently when you see lots and lots of claims, it's people don't necessarily understand what's really inventive, and they're throwing lots of stuff on the wall to see what sticks, you know, thinking that, oh, the examiner will sort it out, you know. But when you do that, you're putting your future in the hands of what the examiner thinks, and we don't necessarily know your invention or know what's important to protect. So, you know, so when you're writing these claims, think very carefully as to what's different and what's important to protect versus other stuff that's not necessarily very relevant.
Is there a window, if you will?
Yeah.
Like you all are anticipating seeing at least 7 strong claims?
Yeah, well,
3 strong claims, 20 strong claims?
yeah, usually about, you know, 1 to 3 independent claims is sufficient to claim all your invention. 20 in most cases is more than enough. An experienced attorney can probably do it in 10, you know, and 20 gives you kind of a buffer.
20 total, right? That's
Yes.
including
Yeah,
independent plus
independent
dependent.
claims, yeah.
As I said earlier about the nexus of features, right? If the claims that are a little bit more frustrating to examine are like, you know, and it has a kitchen sink, and it has a refrigerator, and it has cabinets, right? It's just like, well, how do these elements, as you're going through the different claims, how do they fit together? If we were to put all of those into one claim, right? As Albert said, it's like it seems like you're just throwing stuff out there to see what sticks. As from the examiner's point of view, if I know that it's like, well, there's a nexus between A and B, and then there's a special significance that if it's A, B, and C, then, well, we're getting even narrower, right? And then, okay, A, B, C, and D, right? Those are actually really inspiring to examine because you feel that as you're going through the different claims, the dependencies, if you will, you're really kind of drilling down into that very specific disclosure of what that invention is. And we don't want to be overly harsh. We don't want to make it to where your claims are so narrow that they're not protectable anymore. We want to give you the right amount of legal protection in your claims as what's deserved. And so if we start kind of going down those iterative steps in those dependent claims, it's great to examine. And we can write rejections on the claim, on the independent claim, and any dependent claims that we can find prior art for. And as soon as we can't find prior art anymore, we can indicate allowability on dependent claims. And you can choose to roll that up into an independent claim and get your patent, or you can argue that say, hey, you know, thank you, but I want to argue a little bit more on some of these dependent claims. I think that there is subject matter that wasn't considered, some criticality, some unexpected results maybe. That is so important that one of ordinary skill in the art, based on the rejection that you presented, didn't really consider that.
What is a not independent claim?
So if you had an independent claim that says A plus B, right, element A, element B, and then dependent claim says the above claim plus C, and then underneath that one it's the above A, B, and C plus an element D.
So they're dependent.
Yeah.
Dependent claims.
Yes.
Yeah.
Dependent on the independent.
Yes.
Right.
And the dependent will add more information to the independent claim. The dependent claims encompass what's already set forth in the independent claim.
And again, you can't, once the scope is established, you can't go and like carve out a portion that's already been established. I want to reiterate that because that you'll get, like what, as Pre said earlier, a 112 rejection, right? So you can narrow inside of that, but you can't say, we're going to exclude element A from claim 1, because now I don't know what I'm looking at anymore, right? I needed element A in the first rejection, and then if there's a dependent claim that says, well, we don't want element A anymore, write that in a separate independent claim. That's why you have multiple independent claims.
I'm not sure if this comes up in the slide deck, so you guys can cut me off if it does, but I will say, like, make use of examiner interviews. So what that is like, typically when you file, right, we send you a rejection in writing. And that writing might or might not be confusing to you, depending on where you were coming from and where we were coming from. So for it to sometimes cut to the chase, just, you or the attorney, call up the examiner, set up an interview. We can even set up like a video call, and you can walk through, you can say, hey, examiner, you rejected my claim with this. Why? What exactly do you mean when you say this? And we get about an hour to kind of like dialogue with you on that. And so I actually think that's like very useful, because sometimes like I read something a totally different way than what you were actually intending. And we can solve so many problems on the phone, because I can just say, hey, well, actually what you have there I haven't seen before. Let me just quickly update my search. And then, if you do this, slide this up into this, I can issue a notice of allowance. Instead of potentially going back and forth in writing, and really not getting anywhere, getting frustrated, wasting time, why don't you just call the examiner? I actually personally encourage it, because I feel like it solves like so many problems that way.
What you'll find a lot of times is that two people can be talking and they'll talk right past each other. You're saying one thing and I'm interpreting it differently, and what I'm telling you, you're not seeing it from my perspective and I'm not seeing it from your perspective.
And I think I want to go back to when I was presenting at the very beginning, right? This is something that you see in your mind, and there's multiple tools to communicate, and writing is one of those tools. And if it's not working for you, and if you feel like, the examiners, didn't give me a fair shake at it, calling is a great way. It's another form of communication, a way of meeting of the minds. And you can also, especially with video capabilities now, I recently had an interview where they video chatted in from their lab, and they showed a working example and like what they're doing and described it, so then I could see it. And that's really neat, because I only get to see paper a lot of the times. We're examiners, we can't go into the lab, we can't recreate your thing, and so to see what you did is inspiring, and it helps make those connections that, as they were saying, you're talking past each other. Neither party is wrong, they're just not communicating effectively.
I mean, sometimes the problem isn't in your application. Sometimes, we're looking at a piece of prior art, a paper or something like that, and we're interpreting it one way. And you might say, well, that's not a fair interpretation. You're reading more into it than what's there. And, rather than kind of argue back and forth, the interview can sort of like, well, this is what I'm reading. I think that you're misunderstanding what this paper says.
I want to get clarification on something that Pre said. When I was examiner, and I think it's still true, you could not talk to both the applicant and the attorney if there was an attorney. The applicant can be present during the interview, but we can't talk just to you and to your attorney. We correspond with the attorney or the agent of record, but you are allowed to be present during the interview. Okay? All right.
So, just for clarification, that means that if the attorney files the patent, the attorney then is the on-record person you talked about. So
Right.
The examiner can only talk to the attorney, but you can be listening?
Yes.
Yes. You can't be involved.
You can participate, but you have to have your representative.
Okay.
Yeah, you're paying for your attorney, so let him do his job,
Okay.
right?
How many times can the attorney and you guys correspond?
A reasonable number of times. Usually, for a case, 1 or 2 interviews. You want to if you have issues, have it all in one meeting. Don't call me up and say, oh, well, I want to talk about that. And then 2 days later, let me talk about that. I forgot about that.
I think it's pretty great that
Yeah.
we can communicate with you in the first place. That's awesome.
The
What's that form, Stephen? Sorry, like what's that form? Like form?
an error form?
Yeah.
Yeah, so there's a request now where your attorney can file, say, we want to meet at this time, alternate times are, 1 and 2 below, and then the examiner can select which time slot works best for them, and you don't even need to call up and catch people, play telephone tag anymore. It can be all handled on the internet, email. In the process, one thing that we haven't talked about is like amending claims. We talked about having a very robust specification, and then you put forth your claim limitations. And Pre had said, well, what about adding this from your specification? That's an amendment, and you can do that. You can amend your claims in between prosecution rounds. And so if you add limitations that are present in your specifications into the claims, then the examiner can update their search and see how that corresponds. I bring this up because sometimes I've experienced where claims come in, I write a rejection, and then instead of having an amendment, there's only arguments that like I didn't address the limitations, or they're unhappy. In some capacity, it's just arguments. There's no amendment. And if it's the first round of prosecution, I think that's a really strong time before just filing arguments. Call the examiner, get that interview. Because if you're just going to argue those things, at least see if you're right first. See if you aren't just two ships passing in the night. Get on the same page early, and it's going to help, again, that compact prosecution. You won't have to just keep arguing back and forth.
So we've talked a little bit about there's discussions back and forth, there's arguments, there's next claims. In your experience, how long does it take from when you receive an application to when all the discussions are done and something is ready for issuance?
It depends on how, a lot of it's dependent on how much protection you want. If you want to get the absolute maximum protection, there's going to be a little bit of a fight. Because we're going to be pushing back a little bit and you're going to be pushing at us. And so that will take longer. That might take more rounds of communication. However, if it's something that is very clear that there's nothing else like it out there, and you've written a pretty good claim, you could get an allowance immediately after an examiner looks at it and does the search. And that could be as little as maybe 9 months after you file the application. On the other hand, you have applications that people have fought over it, and I've seen applications go as long as 10 years of going back and forth, back and forth. Now, one way to avoid that is you can oftentimes you get to a certain point where the examiner says, you know what, this is allowable. I'm willing to let you have a patent on this. But you're saying to yourself, you know what, I like that, thank you, examiner, but I'd really like a little more. What you can do is you can accept what the examiner gives you and get a patent, and you can file what's called a continuation application, which is the same application with different claims, and argue for something more. So that way you got your bird in hand, and you can have an opportunity to get more if it's possible. And so let's say you're going on Shark Tank, right? You really want to say I have a patent. So you take whatever the examiner offers, and that way you can say, well, I've been granted a patent, but you can also continue the process and get more protection.
And the continuation application for the date, it goes back to the date of what we call the parent application. So even though your continuation might be filed 2 years down the road, where you're like, hey, wait a second, I want more to my claim, the date goes back to what you'd filed 2 years prior. So.
And with the continuing application, that parent application must be pending, meaning that it hasn't already become a patent. You have the notice of allowance, but it's still pending, so you have to file an application before it actually becomes a patent.
When the question that about average time to issuance, right, from when or abandonment, issuance or abandonment, has definitely decreased. One, we have a smaller backlog, so we're picking up the cases sooner. But then also, this idea is become more of a collaborative effort between the office and agents and inventors, to where we're almost seen as like the first line, if you will. We're trying to get you in the best patent as soon as we can. There's a whole other world out there once you get out to the other side, and you want to have, and it's become a little bit more collaborative. We're trying to get the best prior art in front of us, make sure that we've identified what those inventive concepts, those aha moments are. And then we work with you, some examiners will work with you and your representative to draft the claims that appropriately capture the inventive concept.
One of the things that the office has encouraged, which hasn't been done in the past, is for the examiner to, if they find things that are patentable, to make it known to you as the applicant, to maybe even offer a claim that says, if you draft the claim this way, we'll accept it. We'll issue you the patent. So, oftentimes, there are people that try to write their own applications, and, to be honest, claim drafting is pretty difficult, and people struggle with it. And, as an examiner, sometimes all right, let me write the claims for you, I can do one of them. I can't do the whole thing for you. And it's up to you to decide whether, it's fair or it's acceptable for you. I can't tell you, I can't give you legal advice, and this is good, this is bad. I can just say, this is allowable, this can be granted as a patent. It's up to you to decide if it's good enough for you. Now, again, that continuation is always open to you. You could take that and, maybe right before you write out that check to pay for the patent, you say, I think I can get a little more. So file that continuation and try for a little more. But still, take what's been given to you and, get that patent in hand.
Okay, if we can hold our questions, I have a few more slides to go through, and if we have time at the end, we can answer more questions, and we'll more than happy to answer afterwards, okay? We already talked about the claims in terms of how specific or how general you should be, right? You want to, how is your invention going to be delineated? We use the example of the cap. If you have a cap, too specific would be, I claim a cap with a top wall, side wall, inner threads on the side wall, a spout, a valve, and a mechanism for opening the valve. That's a little specific, right? But if you just claim a cap with a side wall, top wall, and threads, well, that's way too general. So you want your claim to fall right in, where is your invention? It's somewhere in between there. That's where you want your independent claim to fall, okay? Before drafting your claims, we have some recommendations. Think about, what is the invention? What is it that you've invented? What are the pieces or parts that make up that invention? And how do they relate to one another? Do you have more than one invention? If so, you can put both inventions, whether it's an apparatus, machine, or composition, as well as a method of making or using. You can put both of those in the application. You can put claims to both of those in the application. But keep in mind that the examiner could say, well, you know what, you have two separate inventions here. I'm going to request that you choose one of them, and you can file what we call a divisional application for the other invention. But you can put all of that, you should put all that in one. If it's one invention, a method of making and a method of using, as well as what that apparatus is, you can put it in one application. Here's some things that we think you should consider when drafting your application claims. Particularly point out and distinctly claim the subject matter. Can't emphasize that enough. Consider drafting your claims first, and then using your specification to make sure that the terms have what we call antecedent basis in the specification. Because we're going to look for that claim language. We're going to look for that claim language in your specification. Review both to make sure that there are any necessary additions or corrections that need to be made. Again, we want to make sure your grammar, syntax is very precise. We want to make sure all of that is up front. You want to look at your claims and patents that have been issued in your field of technology. Okay? If you're not sure how to write it, just look at one, just look at a couple just to see, oh, this makes sense to me. Do my claims sound the same as these other claims? If it sounds the same as the other claims, guess what? You're not going to get a patent on that. So you make sure that your invention is different in terms of the claims. Again, I already talked about the antecedent basis. That's to make sure that the claim language in the claims is also in the specification. And think about what legal protection you need for your invention and tailor that to your claim accordingly. Now, I do want to offer some precautions. You don't want to use trademarks in your title or in your description. For instance, you don't want to say Velcro, you need to say hook and loop fastener. You don't want to use marks that you intend to register for commercial use. Okay? In the background of the invention, you don't need to say how you conceived the invention. For instance, I was jogging down the street and, this like, I had a moment. We don't need to know that, okay? You want to avoid making claims and using hyperbolic language. Oh, this is the greatest thing and it's going to revolutionize the field. Well, we don't really know that. You hope that it might do that, but don't put that in your specification, okay, or in your claims. Do not include a detailed discussion of the figures that refer to and reference characters in your brief description of the drawing. The brief description of the drawing is just to say, for instance, claim one, figure one is a isometric view of the cap. That's all you need to say. You don't need to go into more detail with that, all right? Lastly, I'm going to turn this one into a positive. The last one there, please proofread your specification, your claims, read your application, and make sure you have gotten rid of all the grammatical errors. Okay.
Can you go back to the slide, actually?
This one?
Yeah, I think avoid making claim of the possible future success.
Yes.
Mm-hmm.
But it's kind of like a significance of your kind of, invention, right? If let's come down to $10, so people say, okay, it's competitive. But if it's 10 million, people say, okay, that's good. I know you probably waste you guys the time, right?
Well, but still, you hope that it's going to make 10 million, right?
Yeah.
But you don't know that for sure. So we just say just avoid putting that in your specification.
I'll walk in the medical field. If you come up with something new and you only treat 10 patients, in a sense of people say, well, big deal. But if you can treat potentially 10 million people, then
Right.
I think that's patent. It's really good.
But that's not probably your patent. So the question is saying you're going to working in the medical field, treat 2 people versus 10 million people. But that's not your invention.
No, it's
right?
It makes significance.
It is the significance that you hope will help.
I think in your situation, what you put would be appropriate. You would basically, stress to the examiner, this is a really big jump. There's a really big difference between what is currently being done versus what this application is. I think what that section really is talking about is your patent is not a marketing document. All right, so so you're not trying to advertise to us.
Right.
But if you're talking about, how significant the improvement is and how much better it is compared to what is existing out there, that's perfectly fine.
What you're saying is actually this machine in the past made 1 bottle with use of this amount of energy. Using the same amount of energy, my machine makes 100 bottles. That's okay to say, and because that's actually like probably part of your, your invention, right? So that's what made your invention better.
The impact of your invention.
The impact of your invention, right?
You good?
Great. Yeah,
All right.
that's good.
Okay. So again, external factors. We looked at this was FY22, quarter 2. Claims drafted to capture the concept of the invention, 42% of the time. We want to make that a little bit higher, okay? Art that was cited in the IDS is material to the patentability. Again, you want to cite the most relevant prior art. We don't need in every container, cap, closure be cited. Just cite what's relevant to your art, the most relevant prior art. You want to make sure that translations of applications, foreign applications, translations of your foreign priority documents. Most of the time, your foreign priority documents don't have to be translated unless the examiner asks you because they're not sure that you actually have a proper priority claim. They might need to make sure that what you have claimed, that you actually have it in the foreign priority. So you might, your foreign priority document, so you might have to have a translation there. Working in the international administration, we do see a lot of applications that are filed that are actually direct translations of a foreign document. So the grammar is not standard English grammar. Okay, so you just want to make sure if you're doing that, that you actually provide a translation that is proper grammar. Okay. Citation to the specification provides support for newly added claim limitations. Remember, we talked about amendments to your claims. We want to make sure that we know where that support is in the specification when you add a new limitation to your claim when you're filing your amendments. Okay. No new matter. It has to be in the specification on day one. Let's see. I think I'm just going to skip over this because you guys look like you have some more questions. So let's just summarize this really quick. We want you to file clear claims. We want to make sure that you set a limitation on your information disclosure statements. Please only cite the relevant prior art. We don't need 2 boxes of citations. Well, they're not boxes anymore. They're actually online, but still, you get the point, I think. Foreign translations, make sure that that you meet the requirements of the translation as set forth in the Manual of Patent Examining Procedure. Inventive concept should be clearly defined. And drawings. This is one of my pet peeves. People would have like sketches, hand sketches of their drawings. And then I would say, you know, I need better drawings. I'm not quite sure what this is. And then they want to file drawings from a draftsman. And they change something. Well, that's new matter. They didn't like that. So if at all possible, file formal drawings at the beginning of the patent application filing. Okay? And they need to be dark, heavy lines. So if you get a draftsman to do that, they will be proper drawings. You don't have to worry about that. But if you have hand sketches, you might have an issue. If at all possible, please file formal drawings. Also, the drawings must show everything that you've claimed in your application. So for instance, most of the time I would require the drawings to show a plastic container or plastic closure if that's what that was being claimed. I need to see plastic in cross-section. So you have to claim, everything that you claim should be shown in the drawings. I want to talk about a few upcoming events that might be of interest to you. We have InventionCon 2022 coming up, August 10th through 12th. I believe it's 4 hours per day. This is a great opportunity to network and meet other inventors, makers, and entrepreneurs. We'll have speakers to come in to talk about their successes, some of their failures that helped them to become successful. So this is a great opportunity. You can scan the QR code, find information on USPTO.gov. We also have a blockchain and IP event coming. It was a series we've been having. I believe it started in May. We're going to have this a continuing series of events once per month. I think it's scheduled out through December at this point.
Every third Tuesday.
Third Tuesday. So if you're interested in knowing more about blockchain, talking about IP and all those things like that, this is a great opportunity for you to read this as well. And I believe, if you want to know more trainings and other events sponsored by the USPTO, you can go to our USPTO events page and find more information. That is the end of the presentation. If we have time for a couple more questions, or if you want to, we can wait, answer questions later. Okay. Are there any other questions?
Yeah, I do have one actually. So in terms of continuation of submission, patent submission. Thank you. So when you submitted, let's say, patent application, okay. Now once it's approved, can you still kind of submit a kind of continue submit something?
Yeah, we have this concept called co-pending. All right, that means that the old application hasn't been finalized and finished. So generally, when we send you a notice of patent allowability. That means your application's been approved for a patent. It comes with a form, and there's a fee that's due. The general recommendation is before or on the same day you send in that form with that check, you file your continuation application. All right. So if you wait too long and your patent's issued, your continuation would be a little too late.
So another question has to do with you guys' time. When we submitted the patent application, how much time frame are we talking about? You have to finish or you get it back to us?
Okay.
30 days?
I'm gonna repeat the question. He's asking about time. Once the application is filed, how much time does the examiner get to move the application along? Let me just start by saying that each art has specific time constraints, okay? So as a container closure examiner, my art time was different than Stephen's. A lot less, okay? A lot less than both of them, but all of them. So it just depends on the art, first of all. It depends on the backlog, which has gone down. I remember at one point, our backlog in my art area was like 3 years to first action because we had so many closure applications, okay? So it's gone out quite a bit. So it just depends on the art, first of all, and the time. Once they pick it up, they have a certain amount of time to, once it's on their docket, they have a certain amount of time to move their application. Once the amendments come in, there's another specific, and that doesn't change per art unit. Once that amendment comes in, they have a specific amount of time that they have to move that application, okay?
If you're wondering, there's a tool on the USPTO website that can give you kind of an estimate as to when you should expect to receive some correspondence from the office.
I would also like to plug that we have a Track 1 application that you can file, and that just gives expedited prosecution. Additionally, we have various pilot programs that have come up, such as with COVID-19, we have a COVID-19 accelerated prosecution. So if there was some type of advancement, whether it's testing or the personal protection devices, those got accelerated processing.
Very good. Thank you, guys. Yeah.
Thank you very much.
Sometimes, let's put it this way, you don't necessarily want to be in a super hurry because I tell people if you wrote the application yourself, you should take that time before you receive correspondence from the office to kind of educate yourself on terms of the patent system, because oftentimes you sit around and nothing happens and then you get this letter from the patent office and you have 3 to 6 months to respond, and it's this long document, and you're saying, "Oh my gosh, what do I need to do?" Right? And so so when stuff happens, it's pretty fast. So oftentimes you sit around for a while, and then lots of things happen.
Well, I'd like to thank you all for coming here today and helping educate us. I know we've had folks here, we've taped everything, and that's going to go out relatively soon. And everything you said was really valuable to the group, and we certainly live it on a day-to-day basis. So anyone that's interested in filing patent applications, university patents flow through the Innovation Institute under our umbrella. And if you go to innovation.pitt.edu, you've got a team of about 10 licensing professionals that 80% of their job is working with our inventors and outside counsel and getting all these applications through on a daily basis. So
I did also want to plug, because we're doing a meeting with some people immediately after this event for one-on-one engagements. If you can't take advantage of that, you can contact through Evan and his team to reach out to us in order to set up one of those one-on-one meetings virtually, and we can do this at really any point in time. So if you're watching this video and it's 2 years later, still reach out.
Is there a cost for that?
Nope.
No.
Is there a card or a way to contact you?
yeah, we'll flow it through.
Yeah.
We'll after this, we'll set up contact information, but we'll flow through our office, and then we would help make the connections happen.
And the people you talk with will be patent examiners, so they will be very familiar with the process, and they could probably answer most questions in terms of filing and and how to read the office action. We just can't tell you. We can't be your attorney. That's the only limitation.
Thank you.
All right.
Thanks. Yeah.
All right.
Thanks. Yeah, appreciate it.